Welcome to White Noise! Yeah! Welcome to White Noise, a live podcast recording at the Indigenous Law and Justice Hub. Tonight, we meet a Wurundjeri Wurrung country, country of the Kulin Nation. We offer respects to custodians of country, the practices of Indigenous legal systems which govern this place, and the long traditions of powerful advocacy which we all benefit from so much. We support calls for treaty over this unceded Aboriginal land. As articulated by our advisory board member and alum, Associate Professor Sana Nakata, our work at the ILJH, the Hub, is all in pursuit of putting the legal profession and its institutions in service of Indigenous peoples' justice objectives. The White Noise series brings Indigenous excellence in law and justice to MLS to share deeply and frankly. My name's Janaea, I'm a lecturer at the Hub, and I'm delighted to introduce this conversation between two people I've learned so much from. Professor Eddie Cubillo joins us tonight as the founding director of the Hub. Eddie is a Larrakia, Wadjigan and Central Arrente man. He recently became the first and the only Aboriginal person to become appointed a professor at this faculty here at MLS. Eddie has a long history working in justice for First Nations people. A former legal aid lawyer, in 2002 he became the chair elected of the Aboriginal and Torres Strait Islander Commission, Yiliriong Regional Council. Professor Cubillo also brings leading expertise on Aboriginal legal services tonight as the former chair of the North Australian Aboriginal Justice Agency, NAJA, the Northern Territory Aboriginal Justice Advisory Committee, and as Executive Officer of NATSLS, the Aboriginal Legal Services peak body of this country. In 2010, Dr Cubillo was appointed the Anti-Discrimination Commissioner of the Northern Territory. He served in this role during the Northern Territory intervention. In 2017, he then took up the opportunity to work on the Royal Commission into the protection and detention of children in the Northern Territory, leading community engagement. Eddie was the director of the Indigenous Law and Justice Hub from its inception until February this year, when he became the director of the newly established Mabo Centre. Eddie's recent academic work focuses on racism and decolonisation in legal education sectors. Dr Carwyn Jones is our current visitor at the Hub, and I've been so lucky to listen and learn this week as he shares his reflections with a range of strong First Nations organisations. We visited this week where you've worked quietly, carefully and respectfully and with brilliant insight at all times, including visiting the Assembly, the Authority and the Victorian Aboriginal Legal Service, and thanks to those who've come out to hear more tonight. Carwyn's iwi is Ngāti Kahungunu. He's the lead academic in the Maori Law and Philosophies program at Te Wānanga or Rukawa, a Maori tertiary education institute in Otaki. As we learn and we think about self-determination, we are so lucky to be joined with someone leading an Indigenous law degree, a program that considers Indigenous law on its own terms. Prior to joining the Wānanga, Carwyn was Associate Professor in the Law Faculty of Victoria University of Wellington, and he's worked and brings knowledge from roles across the Maori Land Courts, the Waitangi Tribunal, the Office of Treaty Settlements. He's the former president of the Maori Law Society, and he's also served as a negotiator of his own iwi in their settlement of their historical claims against the Crown. We recommend to you Carwyn's book, New Treaty, New Tradition, Reconciling New Zealand and Maori Law, the journal he co-edits, the Maori Law Review, and a broad range of publications on topics relating to Treaty of Waitangi, the rights of Indigenous people, and Indigenous legal traditions. So, for those who haven't been to White Noise before, there will be a Q&A time at the end of the event. Throughout the conversation, you can submit your questions, preferably via the QR code, but if that doesn't work for you, via email to MLS Indigenous, or if that doesn't work for you, there are post-it notes at the end of the aisle so you can write questions to Carwyn there. We want to make sure everyone is heard. So please join me in welcoming our excellent speakers.
Yeah, I just want to acknowledge we're on country. Been here 6 years now, and it's been an interesting learning journey for me. We've had the treaty going on foot. I went to one of the first meetings, which was really interesting, and I've been involved with the Treaty Authority with assisting in selecting the current commissioners. Thanks, Sam. I'm still on that too. Yeah, so it's been a real learning curve for myself, coming from the Northern Territory, and from a kid learning about the Aboriginal Land Rights Act, and you know, being connected to country and being able to actually go on country and continue practicing our culture, and that has been really significant in who I am as a person and my values, which yeah, I try and bring in everything that I do as an individual, but also in my role as an academic. So yeah, it's been a journey here, and I just want to welcome Carwyn, who's really helped us in our endeavours to develop a subject, the Aotearoa one, where we travel, and really, you know, try and shine Indigenous content in a different way, actually speaking with people who, you know, who live it and experience it every day, and just to highlight to those students who put their hand up to come to that Indigenous people are always here and always doing what they've always done. And so it's been a real learning curve for myself in being able to experience the students' experience and hearing their journey on those 2 weeks that we're away, and see the change in them over the next few years while they finish their studies. So for me, it's been sad to leave this space, but we all make a mark and move on in our journeys. So in saying that, Carwyn, and I just want to thank all those who didn't go to the football tonight with Collingwood and Hawthorn and gave up your Friday night to spend with us. Really appreciate that. As is always, our starting question for White Noise: who are you, who's your mob, and what are the values which drive you in your work?
Tēnā koe iri a tēnā tātou. Tuatahi, nei rā te mihi ki te iwi takitaki o tēnei rohe o te rā, tēnei te mihi ki a koutou katoa. Greetings everyone, it's a real pleasure to be here, and thank you for the welcome and the conversations that I've been having with people over the last few days that I've been here. My people are Ngāti Kahungunu, which is an iwi, a Māori tribe, from the east coast of the North Island of New Zealand. Ngāti Kahungunu covers quite a big chunk of the lower part of the east coast of the North Island. And my community in particular is from the northern end of that, from a place called Waitangi, which is kind of halfway between Napier and Gisborne, if that means anything to you. Yeah, so that's where I'm from.
Oh, thank you. So in your biography on the Wānanga website, you speak about two of your heroes, Moana Jackson and Justice Joe Williams. Could you share a little to what you admire about each of these leaders in Aotearoa, and what your lessons you carry with you from them in relation to law and justice work?
Yeah, so they're quite different people, and certainly took quite different paths in the work that they did. So Joe Williams is a judge. He's the first Māori we've had appointed to the Supreme Court in Aotearoa, and I worked with Joe when he was first appointed a judge in the Māori Land Court at that time, and I was kind of working as research counsel was the name we called it, but as kind of judge's clerk essentially. And so I got to know Joe and work with him quite early in my legal professional career, and consequently learnt a lot from him, particularly working within that state legal system and thinking about the ways in which you can use the the tools of law. I'm often reminded by, there's a line from, it's actually a line from a song written by a guy called Te Tiriti, who was around in the 19th century. And the line is, mā te ture anō te ture e aki, which is only the law can push up against the law. And, when I think about the work that Joe has done, he's been very much working within that state legal system, settler legal system, and finding ways of getting better outcomes for Māori, making sure the legal system is reflecting better Māori understandings, Māori ways of doing things, and ultimately is kind of more representative of Aotearoa today. But that is a kind of constrained system to be working in, and so the other person that you mentioned, and that I was really instrumental in me, in fact, going to law school. Deciding to go to law school was Moana Jackson, and Moana was a long time advocate on behalf of Māori. He trained as a lawyer, and he also used those tools of the law, but he worked in many ways, kind of chose a path which was outside of the state legal system to some extent. And he was a really important and inspirational figure, especially for those of us Māori lawyers, but also I think for Māori generally, he was quite an inspiration. He always used to say to us, he was great in terms of coming to the law school at Victoria. He was a graduate of Victorian University Law School, and he was always happy and keen actually to come back and talk with the Māori law students there. And he always used to put the question to us. He would say, are you going to be a lawyer who happens to be Māori, or a Māori who happens to be a lawyer? And that always ensured that we were thinking about what it meant to be a Māori lawyer. It meant to be thinking about where we come from, who we're accountable to, and that, we might be trained as a lawyer and be able to use some of those skills, but that was kind of incidental in many ways. And the thing that, certainly Moana was an amazing thinker, and he published a really significant report on Māori and the criminal justice system in the late 1980s, did some other, lots of other really important work, some significant pieces around constitutional transformation. And so, I'm obviously kind of inspired by his thinking and his intellect, but probably more than all of that, very much took from him the way that he works and the way that he held himself, the way that he always acted with integrity, the way that he was always really firm and strong about self-determination. He was very gentle in the way that he presented himself. He never raised his voice and shouted and banged his fist on the table, but that didn't mean that he didn't get angry, and it certainly didn't mean that he was a soft touch. I mean, he was very firm about particularly self-determination and the Treaty of Waitangi, and he was also very inclusive in his approach and the way that he worked as well. And through all of those things, I saw, having opportunities to do some work with him, the ways in which he built up real trust particularly amongst Māori communities, to be able to take a lot of his thinking forward and his work, particularly around constitutional transformation, forward.
I just come back, excuse me, I just come back from the Permanent Forum in the UN, and a lot of the elder states people, spoke really highly of Moana in those early days, and so you really understand the respect that he's got across not only Aotearoa but across the world. And in regards to Joe, Joe's like, we adopted him into the whānau here at the hub, and like equivalent to our High Court judge, he would give us 2 hours in his court with the students, and bring out his guitar and make his associates do sing and welcome us into his court. Yeah, and so we probably, well, you wouldn't definitely get that in our country, right? So that relationship is really strong, and it's really helped assist in regards to those subjects that we trying to bring to this privileged law school, and someone of his ilk to be able to just say, yeah, definitely come and see us. Just let me know and we'll make it happen is amazing. And yeah, we've got so much respect for him and the others that have really go out of their way to give us that time to see the need that students see Māori knowledge and what they do, as you do. So your work on Te Treaty and powerfully reminds us that the Crown's sovereignty was asserted over an existing Maori constitutional order, and that the treaty should be seen as connecting, not merging, Maori and state visions on law and peace. So as Victoria negotiates towards treaty, could you unpack a little for us about what treaty relations offer for thinking and practice in Indigenous Crown relations?
Yeah, I mean, one of the really important things I think of in terms of what treaty relationships provide is that, when you think of what a treaty is, then it's an agreement and a relationship that's established between two or more sovereign parties. And just even that in itself requires an acknowledgement and a respect of each other's authority. And so thinking about the way in which those treaty partners come into negotiations or entering into discussions about treaty as each having authority in their own context and sourced in their own legal systems and constitutional traditions. And for treaties to maintain, to endure, then it's important that those two sources of authority and constitutional traditions continue to be recognised. If they're not, then you no longer have the distinct parties to the treaty to form that treaty relationship. And I think one of the things which we have sometimes struggled with a bit in Aotearoa, in terms of often the non-Māori perception of what the Treaty of Waitangi was all about, was the idea that it made us all one people. In fact, I would suggest that what it did was it recognised two distinct peoples, well, in fact more than two, if we think about the diversity of tribal groups that entered into the treaty, but these distinct peoples who were entering into a relationship and were going to find ways of working together, and the language that the tribunal has used and that the Mātiki Mai report has used is talking about these two spheres of authority that are brought into relationship with each other by the treaty.
So you just mentioned that report, and you work with Moana on that, as well as Margaret Mutu, is it? And which was, as you said, was a huge consultation process in 2010 towards constitutional transformation to honour the treaty relations. What did you learn from being a part of that process? working with those people?
Yeah. So this was a process which was led by Margaret Mutu and Moana Jackson, and there was a kind of working group around them that I was part of. And we were set these terms of reference by the National Iwi Chairs Forum to develop a model constitution for Aotearoa that was based on not only the Treaty of Waitangi, but also the 1835 Declaration of Independence, also Māori kawa and tikanga, so Māori laws and protocols, and also any other kind of international instruments that might be relevant, for example, the Declaration on the Rights of Indigenous People. And so we were charged with figuring out how to come up with a model constitution. And Moana's approach, as I mentioned, Moana always, his instinct was to take this very inclusive approach, was always to try and talk to as many Māori people as you could in the process. So for this work where we were wanting to identify Māori constitutional aspirations, his approach, he said, we ought to just go and meet with as many Māori groups as we can and find out what they have to say. And this was, the consultation meetings took place over a period of about 3 years, and there were over 250 meetings held in that period. And they were different kinds of sizes, different kinds of groups. So some were tribally based groups, organisations. Some might have been organised through, like in a professional context, like maybe university staff or students having a meeting, those kinds of things. We had some opportunities to go into prisons. There was a young people's group who were tasked with specifically engaging with young people on this topic. And I didn't go to all the meetings, far from it. I only went to a handful of them. Moana went to just about all of them, and would sort of be supported by whoever was available and around, or had some particular connection to the group. And so when we had some of our meetings in Wairoa, which is where I'm from, and they were some of the earliest meetings we had through this process. So I went with Moana to those meetings, and they were really, it was really a profound experience, because we didn't know who was interested, how many people were going to show up. When we first arrived, it was just like a few of my aunties that were there. And it was in the middle of winter. It was like, I think, a Monday night or something. And so we thought, well, whoever's there we'll talk to. But actually, pretty soon, we weren't in a big space, but pretty soon the space started to fill up with people, and people of all different ages. So we had old people there, young mums with their kids coming along, teenagers. And one of the things that was really striking was how ready people were for these conversations. And we often used to talk about how the fact is, if you go in and you say you will talk about constitutional transformation, people's eyes will glaze over. But when you start talking about actually the ways in which decisions get made that affect people's lives, people are very keen to have those conversations. And certainly in Māori communities, it was really clear that not just they were ready to have the conversations with us, but they had been having the conversations amongst themselves for a long time. They'd been talking about the issues, they'd been reading about the issues. They were well prepared to start thinking about how we might address some of these questions about developing a model constitution. And so that was probably one of the kind of two key takeaways was, first of all, just how ready people were, and how, I found that really exciting and inspiring. But also that approach of trying to be as inclusive as possible, trying to make sure we reached people who perhaps don't usually get asked about these sorts of questions, in the end, made for I think, a really powerful report in the sense that we knew this was being based on all these conversations that we had had.
Thank you. So you've noted that the Crown's treaty settlement process prioritises certainty over justice, placing pressure on Maori legal traditions. So drawing from your experience representing your people in major settlement, and one was about 100 million or something, could you speak to the limitations of this model and what it reveals about the Crown's reluctance to engage with ongoing Maori legal authority?
Yeah, so I think, in Aotearoa we've got a treaty settlement process which is designed to settle the historical claims under the Treaty of Waitangi, and so these are conducted kind of community by community through direct negotiations between the settling group and the Crown, sort of arm of, or used to be an arm of the Ministry of Justice. And one of the things through that process that I have found kind of problematic, there are a couple of things. One is that the framework for those negotiations is set by the government, and there really isn't much scope for negotiation about what the nature of the negotiations is going to look like and what might be up for discussion even. So there's quite a fixed and rigid framework, and that involves the kinds of outcomes that you see coming from that. There's a dollar value to it, and so there's a commercial aspect of the settlement which might be in cash or it might be in return of land. There are some elements which might give you particular input into resource management or environmental planning processes, those kinds of things. These are all kind of taking place firmly within the kind of Crown's understanding of state power and how it works, and are all things that, while it might not be keen to hand over some cash, it is kind of comfortable in the sense that it's not stepping outside. It's how it understands its authority operating. Whereas one of the things that I think would be really helpful and would lead to kind of much more enduring settlements is if there was a proper engagement with Māori law and Māori authority through this process. And that would start, first of all, from figuring out what the negotiations would look like. But it would also, I think, lead to quite different sorts of outcomes, certainly a less boilerplate kind of template of what a settlement looks like, and would provide more opportunities through the process for, yes, there might be times where Crown law and the Crown legal system might be the governing legal system, but there might be other times where Māori law ought to be the governing framework for making those decisions or facilitating those conversations. So there's that aspect, but the other aspect that I think has been quite problematic with the settlement process too is the way in which they've been framed as full and final settlements. So they're very much, even though some of what you get from a settlement are future-focused relationships, the framing of these settlements is in fact about an extinguishment of rights, and it is about a kind of ending of a relationship where in fact it should be about a resetting and about thinking more about setting up a future relationship.
See the front row there, they're all nodding and, oh, did we do something wrong? But so just on those thoughts then, could you share a little for us on your reflections from the negotiations and what lessons you might offer to our traditional owners groups here seeking to negotiate agreements with the state under the Vic Treaty negotiations framework?
Yeah, so I guess one of the things that, as I mentioned, because you're working within a framework which is very set by the Crown, back home in our settlement process, that means, for us as we're working through our settlement negotiations, that there was a whole lot of stuff that we would just run up against a brick wall with the Crown. We couldn't push them any further. We couldn't control some of that stuff. they set the framework, and they could walk away whenever they wanted without really much skin off their nose. But one of the things that we could control was the way in which we organised amongst ourselves and the way in which we communicated in our own, in our own communities, so that we worked really hard to try and make sure that there was good opportunities for discussion across the community and across different kinds of groups, making sure that we were including young people as well as elders and everyone in between, that we had regular opportunities for both information from us to come back about how the negotiations were going, but at least as importantly, that opportunities for people to tell us about what they wanted to have happen, what their aspirations were, where they thought we needed to do things differently. But just building up, having those conversations in itself is important. So the transfer of information and the communication of information was really helpful and useful. But the importance of regularly coming together so that we all were engaged in the process as much as possible and working in it and felt as though this was something that was a collective effort, I think was an important part of that. The other aspect that I think was really important through our settlements back home, and I don't know whether it has application here, but is just thinking about, while we were dealing with the specifics of our own historical claims and working within quite a narrow framework, to try and make sure we had our eye on the kind of broader legal and policy system. And I think one of the things that we've seen recently with our current government, which is rolling back a whole lot of things in relation to Māori rights, is that, actually if you kind of assumed that your rights were going to be protected through partnership agreements, and for example in the child welfare and protection space, and make your settlement on that basis, and then the government comes around and removes the provisions that were in the child welfare law, then your settlement is kind of diminished. So I think it's really important to keep that broader focus on what the broader landscape looks like, and make sure that there are, try and think about how to build in protections against that.
So the highest court, the New Zealand Supreme Court, in 2022 handed down a judgment in Alice and the King, which affirmed that tikanga Māori, or Māori law, and custom is the first law of Aotearoa and forms part of the values of the common law of New Zealand, and will continue to be recognised in the development of the common law in cases where it is relevant. This has accelerated movement towards prominence of tikanga-based thinking to state legal institutions. How should we understand this shift, and how do you feel now about risk in this project?
Yeah, so it was an important shift, I think, and the shift was really one of which, the New Zealand common law had always been able to recognise tikanga Māori, Māori law, as customary law, so long as it fit the particular frame that the common law said was acceptable as customary law. And essentially that meant needing to prove it as a fact. It's a fact that this custom exists and people know that it exists, and it's not contrary to any legislation or kind of key values of the common law. Now, the shift in Alice was really this recognition of tikanga not as just a provable fact, but as a source of law itself. So it's kind of, for a kind of law school crowd, kind of shifting the tikanga consideration from the facts into the legal reasoning in a way. And that's a big shift and an important shift. One of the interesting things about that particular case was that there was no particular Māori dimension in that case. The appellant involved wasn't Māori. None of the parties were Māori. It wasn't about a Māori issue. And so the other part which was quite significant was the fact that the Supreme Court were saying that, well, it doesn't matter whether there's a Māori dimension to the case or not. If tikanga is a source of law in Aotearoa, then it can apply in any context. Now, some of the cautions that have arisen from this case, though, have been about ensuring that Māori maintain control over determining what Māori law is. And so, often the concerns have been that, well, now, okay, we've got this incorporation of tikanga into the New Zealand state legal system, but we've got a whole lot of judges, almost all of whom have no background or expertise in Māori law at all. Some of them recognise that and are quite cautious about the way in which they're engaging. Others of them don't recognise that and enthusiastically wade into these matters which they don't actually have any, certainly no expertise in, but no authority to be determining what Māori law is as well. And so that's part of the challenge, I think, now is trying to think about how can this be done in a way which is authentic and maintains the authority of Māori to be the ones who determine Māori law.
So since we're making a shift, can we talk about legal education? You're part of a project with a collection of the powerhouse Māori legal academics looking at legal education transformation in New Zealand's law schools and advocating for bijural, bilingual and bicultural legal education. Could you unpack that a little for us and the type of transformation this work is talking about?
Yeah, so I was involved with some work that had involved all of the Māori legal academics around the country in some shape or form, and we were exploring ways of, or what needed to happen to, we talked about kind of indigenising the LLB, so the New Zealand law curriculum. And some of the kind of key things that we've identified through that report is that we were wanting to create law schools and law graduates and a legal profession that was Eddie mentioned, bijural, bilingual, bicultural. And so what we're talking about there is the bijural part is the kind of recognition of the two sources of law, that as is happening in the courts, that law schools would need to engage in thinking about, well, what does that mean for our teaching of law in Aotearoa? How do we recognise and teach across these two different legal orders and recognise these two different sources of legal authority? We said that that's important and central to the function of law schools, but we also said that in order for that to happen effectively, that needed to go along with some other changes. So that the bicultural part was that law schools needed to fundamentally change as institutions to become more bicultural, to become safer places for Māori staff and students, and for the teaching and learning of this law, this bijural law. And we said both of those things would be supported by the law schools becoming bilingual. And so those three components we identified as, we said, those ought to go together. If you start to separate them out, you're only going to very much sort of partially achieve what you're wanting to do, and could in fact be quite harmful. What happened subsequently was that there was a resolution from the New Zealand Council of Legal Education, who's the professional body that moderates the core courses in the New Zealand law degree, and they passed a resolution which required there to be some Māori law content in all the courses that they moderate, which on the one hand we thought was great because this is partly what we had been trying to achieve, but on the other hand that immediately just carved off the curriculum content. And so all the focus became on changing the curriculum, which was needed, but then left those questions about the culture of the institution, those questions about becoming more bilingual were left to the side. And the other piece of it that was that we had been strongly advocating for was that this process needed to be, the implementation of this needed to be Māori-led. And again, with the Council of Legal Education's decision, it also meant that the process was kind of back in the control, firmly in the control of the law schools in developing these courses, and likely not actually to, well, not necessarily to be Māori-led as well.
That's pretty interesting. It's a long way to go here, mate. I interviewed Carwyn for some research I'm doing, and I sent it back to him, transcribed, and also the recording. And he sent me a message back apologising that he's laughing throughout the whole interview. So this next question, no laughing, all right? So we've both moved away from mainstream law schools, and you've transitioned from a university housed in colonial government building to a Wānanga grounded in Maori values. Could you share what motivated that move and what your work at the Wānanga offers to broader movement of Māori law, philosophy, and yourself as a Māori man, as well as a parent of Māori children, and then also as a Western legal scholar?
Yeah. So I was at the law school at Victorian University for about 15 years, and then for the last nearly 4 years I've been at Te Wānanga o Raukawa, which is a Māori tertiary institution. And you know, really what prompted the shift was that that I could see that the law school was not a safe place for our Māori students, and that the thing that took me a long time to realise, that I was slow to realise, was that in fact my presence wasn't necessarily helping the issue, but was perhaps masking some of the problem as well. And it was really when I was some of the stuff around transitioning more towards having more Māori law content in the curriculum, I think had raised a lot of these issues, and so I was seeing them a lot more. I was getting some insight, or more insight, into what was happening in other people's classes. You know, I was happily going along in my own classes, doing my own thing, but it really came to concern me, and when I started to see more what was happening in other classes and see those were really quite unsafe spaces, and as I say, that I wasn't able to, I wasn't providing much protection in those spaces. So I moved to the Wānanga, and I'd had a bit of involvement with the Wānanga and with the Māori Laws and Philosophy program there. I'd been an external monitor for their program for a number of years, so I knew the program pretty well. I'd always really loved that program. Some of the key people involved there were, Ani Mikaere was the sort of long-time person involved in running the program, and Moana Jackson also had a long-standing relationship with the program too. And so, I was really taken with this program. I really excited by the ability to focus on kind of Māori law in its own right, rather than when I was at the law school, I taught a Māori customary law course, but that was all about just thinking about where the settler legal system recognised Māori law, and just in those little spaces. So it was I really have enjoyed the shift of thinking about Māori law as Ani says, the first law of Aotearoa, and also when our program as well, through the whole institution and in our program, is a real thread of thinking about self-determination and tino rangatiratanga, and the way in which Māori law might support that. So, I think thinking about what it means for the scholarship around Māori law, or for me as a Māori man, as a parent of Māori children, it's that kind of validation, I suppose, legitimation, normalisation of looking towards our own processes and systems as having solutions for the legal issues that we're encountering, as well as a whole lot of other issues that we need to address today as well.
Yeah, it was for myself. It was pretty confronting going there. It was sort of made me think about those sort of things as well. Like, am I wasting my time in this environment? And I came back and really thought deep about my place in this environment. Yeah, and so it was, and it was confronting in a good way. Like, it was just culture immersed in everything, right? Even the buildings, and they tell us how they made them and why, and so it just sort of really confronted me, and like, geez, what am I doing? And so, so I remember when you were laughing, I was like, now I get it. So the Wānangas high research degree is something, it deliberately operates outside the regulated PhD framework, and hearing about this week has had us thinking about research ethics and accountabilities in research. I want to invite you to reflect a little on what it offers to Indigenous people to work outside the state system in this way.
Yeah, so we have our, we've got a kind of a range of degrees from kind of certificate level, diploma, bachelor's degree, master's degree, and our highest degree has been deliberately kept out of any other kind of framework. So in some ways it's like a PhD, but it's deliberately not a PhD. It, first of all, is the accountabilities all come back through to the community. So we have at the Wānanga, the institution where I work, a group of people who are charged with the kind of maintaining the cultural integrity of the institution, and they are the ones who kind of oversee this higher degree program. It's called Kaurutanga is the name of the program. And so they are the ones who review proposals that come in, advise on how you might carry out this project, are involved in determining about what the outcome of the project should be. And these are projects of the kind of scope of a PhD, in the sense that you would expect them to be kind of 3 to 4 years of work and produce something substantial at the end of that. And importantly, it means that the output doesn't necessarily need to be just a whole lot of written words. It can take different forms. It also means that the accountability right from the very beginning is going through to the community, and so is being done in a way it has a kind of built-in ethics component to ensure that it's the projects are things which are useful and contributing to the development of Māori knowledge, but they're being done in a way which is consistent with how the community wants them to be done, and just keeping it outside of being required to undertake any other kind of restrictions or criteria enables that to be done purely in a way that the community wants.
So at a time of growing pressure on Te Treaty in Aotearoa, you've been active in both commentary and movement work. How have you understand your responsibilities, and how do you decide where to focus your efforts in this movement?
Yeah, so first of all, I think, I've worked in the area relating to Te Tiriti, the Treaty of Waitangi, for a long time, and have both a strong commitment, just from myself, but also I feel as someone who has worked in that space, a kind of obligation and accountability back to the community to help progress those issues and recognise better the partnership or the relationship established in Te Tiriti or Waitangi. One of the ways in which I do make decisions about where to focus and how to engage, and that I've actually found very helpful being at the Wānanga, because the Wānanga has a kind of set of guiding principles that it uses to really to filter all the decision making. We talk about them a lot. We talk about them with our students because they're expected to behave in accordance with these values as well. And they're all Māori values, but they reflect, for example, the importance of relationships, the importance of nurturing and caring for others, the importance of maintaining and looking after the environment, the importance of Māori language, a whole lot of things. And as I say, we use them constantly at the Wānanga to talk with our students about, to make decisions in academic board meetings. Those are always the principles that we come back to in instances of, if there are disciplinary issues that need to be addressed with students, that's the framework that we use. And so that's also the framework that I look back to and reflect on in terms of thinking about where I should be putting my time and energy. And, we've just got a new chief executive, but our former chief executive, she was always very clear. She said, these are the principles that we're trying to express. If you're doing something which doesn't express at least one of these principles, then stop doing that and do something else. Do something that does. So, yeah.
So let's come to the last question. How do you switch off from all the white noise that comes with working in Western law and stay grounded in who you are as a Māori?
Yeah, that's a good question. So I'm really lucky, I think, working at the Wānanga because it is a space that I find quite restorative and replenishing and, just normalising being Māori in that space. And those of us who work there recognise it is often a bubble, but it's a really nice space to be. And it's given me opportunities to do some things like continue my Māori language learning journey, which is, still very much a work in progress, but, that I think is very restorative as well. So those kinds of things. And then the other aspect is I've got 3 teenage kids and they keep you pretty grounded.
Yeah, no dramas. So there's going to be an official thank you, but just before we finish, I want to personally thank you. And, you're a respected Māori scholar and legal thinker, and I want to thank you for taking the time to travel to Australia and generously share your knowledge and insights. And we recognise the significance of leaving family and community to do this work, and we're truly grateful. So just when I established the Indigenous Law and Justice Hub, I worked really hard to foster our commitment to Indigenous excellence, and through sharing of knowledge across First Nations, these exchanges are vital to bridging the divide between Indigenous and colonial legal traditions, a divide sustained by the ongoing non-recognition of Indigenous sovereignty and legal authority in this community, in this country. And so I just really want to thank you and others that have come and give us their time and really give students the opportunity when we travel over on country. So just really want to say thank you.
Okay, now we've got... thank you number one, and we'll do it bigger and even more at the end. We've got, half an hour for audience questions, so write your post-it notes, and James and Elise will come and get them. The online question piece is, going off. There's heaps here, Carwyn. So firstly, Carwyn said that the integration of Māori legal education or Māori law into law school carved up important topics and issues, broke things apart, like bicultural work. Can you please share an example of how this happened or what this looks like?
Yeah, so I guess the thing was that when we were thinking about what needed to happen in order for us to teach, I think safely was the biggest concern. Again, thinking about the safety of Māori staff and students in particular, and if you were going to be delivering Māori law content in the law curriculum. And one of the things that we identified was that actually that required some quite fundamental changes in culture in the law school, because what you know, at around the time when I left the law school, where these issues were coming up, one of the things we could see was that it was not safe for Māori students, because we would have faculty and other students who were expressing quite racist ideas, views, not always intentionally, sometimes intentionally. And just introducing Māori law content into the degree was not going to address that, and was likely going to increase those kinds of racist comments and statements as well. And so that's why we saw that it needed to go together, that kind of cultural change in the law school, alongside the curriculum content.
Thank you. This question says, if Māori wanted to self-govern, mana motuhake, have you considered the pathway that would need to be taken from a legal perspective?
Yeah, so, I mean, one of the things that we have with the work I talked about that Moana Jackson and Margaret Mutu and I and others were involved with, the Mātake Mai report, was all about trying to think about setting up some kind of constitutional models that would deliver effectively mana motuhake for Māori. Now, this was work that we were thinking on a kind of national level, and the work that we did was to identify Māori constitutional aspirations from the workshops and discussions we had. But we knew that then the next step would be to talk with other New Zealanders about, well, what are your constitutional aspirations, and how can we make those fit and work with what Māori have told us. And so when we were looking at this work, we were thinking of, yes, one of the things actually people told us was that they wanted to see, even though we were talking about a national constitution, people wanted to see plenty of space for local autonomy. And so some of the things that we talked about through that process were thinking about, well, you might have different kinds of elected representatives, maybe. So maybe that you have people that you're voting for individually, but also you're also sending a kind of iwi, sort of nation people representative delegate as well into whatever the decision-making body is. The key part of all of it is thinking about understanding the need to make space for that Māori sphere of authority, and the recognition that needs to be not subordinate to the Crown's sphere of authority. Now, once you've got that basic framework, then there's a lot of work you can do within each of those spheres to think about, well, exactly how would this look if we were to do this. But we are, like, always really, I always think, really fortunate to be able to look back to the Treaty of Waitangi, which set out this relationship and said, yeah, we can have a system that recognises two spheres of authority in the same piece of land.
Thank you. Well, there's so much here, which direction to go. Okay, so someone has asked about your experience at law school at Vic in 1995.
Very precise.
They've asked, yeah, someone knows. They asked, do you consider this to be a safe place for you there as a Māori? But maybe if you wanted to talk also more broadly about your legal education experience.
Yeah, no, I mean, it certainly wasn't a safe place for Māori students in 1995. You know, and, you know, I certainly experienced plenty of racism being expressed. Most not directed at me, I'm pretty fair. But often people making racist comments thinking, well, maybe there's no Māori in the room. And so that, there's plenty of that. Yes, one of the things that I often reflect on, we've had coming through our program at the Wānanga, our Māori Laws and Philosophy program, in the postgraduate part of that program, we've over the last few years have had quite a few Māori lawyers coming through that program, some of whom I knew as law students when they were at Victorian University. And one of the things that really strikes me, particularly when they reflect on, you know, after the first kind of block of time we have together, and they reflect on what a kind of different experience the Wānanga experience is from law school. They say, I didn't know learning about the law could be fun. They talk about the fact, yeah, they reflect on what a different experience it is from law school. And one of the things that, I mean, that makes me quite sad, really. And these students too are often students who did very well at law school and have been very successful in their legal career. And, you know, even those students, those Māori students are being underserved by our law schools. And there are a whole lot more who are not getting through law school because they're being underserved there.
Okay. Under the current government in Aotearoa, what do you see, this kind of asks you to look into the future, as the future of Te Tiriti, the Waitangi Tribunal as well?
Yeah, so we've got a government at the moment which seems pretty intent on trying to take away Māori rights, of trying to remove the treaty from our law as much as possible. There's a review underway at the moment of the Waitangi Tribunal, and although one of the ministers responsible for that review has said, well, we're not predetermining anything here, there have been other ministers in Cabinet who've talked explicitly about you know, we've got this review going so that we can rein in the Waitangi Tribunal. So I think the kind of intent of where they would like to go is pretty clear there. You know, the Waitangi Tribunal, I think, has, you know, it's been in place for 50 years and has played a really important role in shaping the discussion around Māori rights and the Treaty of Waitangi and New Zealand history, and you know, I think bringing to light a whole lot of history that most New Zealanders would never have encountered otherwise, and often shaping over a long term the kinds of conversations that we can have about, than we do have about Te Tiriti. So while this particular government seems pretty intent on removing the treaty from our law, actually some of the response that we've seen to that, the huge numbers that we saw turn out in opposition to some of the government's proposals, hundreds of thousands of submissions that have been written, I think we're at a point where there's a huge number of non-Māori New Zealanders, as well as Māori, of course, who understand the real value of thinking about treaty relationships and the benefits that that can bring, and also who are not scared of Māori self-determination. I mean, one of the things that I've been really struck by over the last few years in particular, and that a younger generation, people who are in their 20s now, most of them are quite comfortable with the idea of talking about tino rangatiratanga. This is non-Māori, I mean, who are comfortable with the idea of thinking about what tino rangatiratanga might mean, and aren't scared of that idea. And so I think there's a generational shift that we're likely to see, no matter what this current government does. Governments come and go, but I think there's a momentum behind Te Tiriti that will maintain.
Thank you. I'll group a couple together now, which are reminding me of earlier when I said you've been on the news a lot recently, Carwyn. You said there's a lot to be on the news about. So this says, what strategies have you found successful in dealing with constitutional conservatives who may or may not have racist or far-right prejudices? A different iteration of that question says, who would win in a fight, and let's say an academic one? Hannah Rahiki Clark or David Seymour?
Well, Hannah would, I think, win in most kinds of fights with David Seymour. Certainly an academic one, because David Seymour doesn't listen to anyone. So it's very hard to put up a good argument if you're not prepared to listen to what anyone else is saying. In terms of dealing with constitutional conservatives, one of the things that, like I mentioned, part of the intent of the Mātaki Mai report was that we'd identify and talk about Māori constitutional aspirations, but take that conversation out further. And Moana, before he died, had already begun some of that work, and going into places that he wouldn't usually go into. And I was just reminded of this because in a few weeks I'm going to talk to a Rotary Club about, they've asked me to come and talk about these issues in relation to the treaty. They know, the guy I spoke to has read lots of my stuff. He knows my position on things, and seems genuinely willing to engage in thinking about those things and sharing that information and views with those other members. There's some work that worked with some people who kind of deal with thinking about how to communicate research and get people engaged in good, constructive conversations about research-based policy. And one of the things that they talk about is that people, sometimes us people involved in research would like to think that if you put the evidence out there, show it to people, they see it, and they'll act based on the evidence. But that's not what happens, and that people act based on their values. But important to remember is that there's not just one value that people have that drives all their actions, there's a range of values. And being able to talk with people that are tapping into some of the more productive and constructive values. And so, for example, it's not necessarily constitutional conservatives, but for a lot of people who are quite conservative, they still have might still have quite a strong sense of ideas and values about community and even solidarity and even justice that can be drawn on to help have these conversations with them.
I'll ask you another question about seeing yourself in the treaty relationship, which is, so I'm Anglo-Indian, my mom's here. We found out Caroline here is also Anglo-Indian recently. There's some beautiful writing coming out of Aotearoa about, and maybe this is more distinct to historical treaty relationships, but thinking about the place of Pākehā or Crown is seen as so white, the place of how people of colour, migrant communities see themselves in the treaty relationship, and I was wondering if you could reflect a little bit on that in your context.
Yeah, I think that's a really important point, and indeed some of the really important statements of support that came out in opposition to the Treaty Principles Bill were from groups. I'm thinking about one submission in particular from a group, they call themselves Asians for Tino Rangatiratanga, who were there wholeheartedly in support of having this, like I say, not scared about Māori self-determination and what that means. And I actually think in terms of the treaty relationship, I think that the treaty relationship itself provides a mechanism for thinking about recognising and engaging with difference. And it does that in a particular context of thinking about Māori self-determination and authority and that distinct community. But I think it does then open up possibilities to have more conversations about what are other kind of consensual ways of recognising difference, different authority, different communities alongside that. And I've been really interested in the adoption, increasingly I think in the last couple of, since this government's been in place, of people talking about tangata whenua, so people of the land as Māori, but also tangata tiriti, the people of the treaty. And I think that's a more kind of inclusive term than, say, Pākehā, which often has an association of white New Zealanders. Tangata tiriti is about people who belong in New Zealand by virtue of the treaty. And I think that's quite an important kind of when people use that to talk about themselves, a statement about their commitment to that relationship.
Thank you. Given the pitfalls you describe about negotiating with the Crown's colonial framework, particularly of rights being extinguished or agreements being undermined by new governments, are there areas that you would recommend that Koori people or Aboriginal Victorians refuse to negotiate in treaty negotiations here in the state of Victoria?
Yeah. So, like only in a kind of very fundamental sense, I think, would I suggest that the treaty itself is going to be grounded in the authority of your people, your community. That's not something that can be up for negotiation, is what I would think.
Thank you. I think, that's a beautiful note to end on tonight. Carwyn and Eddie, both of you, thank you so much for your time. Please put your hands together.